Prepare yourself, my fair friends. Fortune telling can be criminal.
If you would like to learn about fairy folklore, delve into modern fairy faith spirituality, and explore fun and fanciful fairy-themed events, please subscribe to Fairy Fortunes for new videos every Friday.
Hello, my fair friends. I'm Ruby Ruse, and today on Fairy Fortunes, I am continuing fortune telling and the law, this time specifically focusing on the crimes that can be associated with fortune telling. If you have not seen part one, I do recommend that you go back and watch that. In that episode, I discuss how many municipalities throughout the United States still carry ordinances and prohibitions regarding fortune telling, but also witchcraft and other occult arts. So highly recommend that you go back and watch that video. Now, before I continue on, I just want to make mention that I was a police officer for 20 years. So I do have a little bit more information about criminal law than a general citizen might have, but I certainly have less information than perhaps a lawyer or judge. And I do want to just make it clear that this video is not to constitute any kind of legal advice. It is simply to provide information, and more than anything else is for your entertainment. And do keep in mind that the United States is a very large place. And if you're not familiar with the government workings of the United States of America, each of the 50 states and the 2 territories have laws that are unique and specific to that municipality. So that's quite a vast undertaking. So because I personally am here in Illinois and I was a police officer in the state of Illinois, I limited this research to Illinois law. So while laws are going to be very similar throughout other places in the United States, there are probably some differences. So if you are interested in this topic of fortune telling in the law, I highly recommend that you conduct your own research and look into the compiled statutes for your own municipality. So one of the more innocuous crimes that a fortune teller could be charged with here in the state of Illinois is something called disorderly conduct. Disorderly conduct is when a person knowingly does any such act in an unreasonable manner as to alarm or disturb another and to provoke a breach of peace. This is classified as a Class C misdemeanor. Now, what that means is that the penalty is up to 30 days in jail and up to 2 years of probation and a possible fine of $75 to $1,500. And it can be all of those things or a combination of those things, but not more than those things. The thing about disorderly conduct is that another citizen would have to articulate very specifically how their peace is being disturbed. How are they being alarmed? And what that means is that if someone is just uncomfortable, meaning that maybe they don't agree with the practice of fortune telling, that wouldn't necessarily be enough to have disorderly conduct. They would have to show how they're being disturbed in a very unreasonable manner. So disorderly conduct is a possible charge that a fortune teller might face. It's more likely, I think, that deceptive practice would be a better charge to use in a situation where people are trying to enforce a criminal law against some kind of fortune teller. Deceptive practice is described as when a person knowingly makes a false or deceptive statement addressed to the public for the purpose of promoting the sale of property or of services. Deceptive practice is a higher charge than disorderly conduct. This is a Class A misdemeanor, which means that this could be up to 30 days in jail, but it also could be up to a year in jail. Charging could also include, again, that 2 years of probation. And here the fine is also $75, but it can go up to $2,500, so more than the charge of disorderly conduct, which is a Class C misdemeanor. Now, I mentioned that this is generally a Class A misdemeanor, and the reason I made that stipulation is because the value of the property taken by the person committing deceptive practice, the value of that property then raises the level of the charging. So the more money a person takes through the criminal act of deceptive practice, then increases the charging level of the crime. Now, in the state of Illinois, there are particular dollar amounts that delineate how the charging increases. So, for example, when the value of property obtained in a single transaction or in separate transactions within a 90-day period exceeds $150, this is a Class 4 felony. What a Class 4 felony means is that this is usually punishable by at least 1 year in jail. So a misdemeanor is up to a year. A felony is at least a year. And then with felony cases, after they have served their sentence in prison, there might be a period of at least 18 months of what's called a supervised release period. That might mean that they are not serving in a physical prison, but they might be on some kind of monitoring system. And there may also be an additional probationary period assigned after that as well. So I do want to take a minute and just highlight that 90-day clause within the felony description of deceptive practice a little bit more. Because if a person went to see a fortune teller multiple times within a 90-day period and paid, let's say, $50 each time they went to see that fortune teller, we would now be in that realm of that $150 requirement that would then raise the charging to a felony level, where a fortune teller would be facing at least a year in prison. So this is a charge that I think is one to very much keep in the front of your mind as a fortune teller and as a person seeking the services of a fortune teller. And I also just want to mention part 1 of fortune telling and the law once again. In that particular video, I do discuss the Constitution of the United States regarding the freedom of religion and the freedom of speech, because in the description of deceptive practice is that clause of false speech, which in the context of fortune telling has been successfully challenged here in the United States. So if you're interested in that information, there is a little bit of that in Fortune Telling and the Law, Part 1. So another higher scale charge that a fortune teller could potentially face criminal charging with is the crime of simply theft. Now, I know that seems a little bit strange, but let me articulate the definition of theft here in the state of Illinois. A person commits theft when they knowingly obtain or exert unauthorized control over property of the owner, or obtains by deception control over property of the owner, or obtains by threat control of property of the owner. Theft of property not exceeding $500 is a Class A misdemeanor, which means less than a year in jail, but more than likely more than 30 days in jail. And then, like we saw in the case of deceptive practice, there are circumstances where theft can be upgraded to a felony offense. One of these cases is if the property taken was done at a school or place of worship, which I do think affects fortune tellers because they might be perhaps entertaining at a church function or a school function. So you do want to make sure that you check the laws in your state before you agree to do an event like that, because here in Illinois, that could potentially be a felony offense. And then with theft, the higher the value of the property taken, the higher the charging is. So for example, property taken that is more than 500 but less than 10,000 is a class 3 felony, which means that the sentencing begins with 2 years of prison term and can go up to 5 years. And then once you get past $10,000, that is a higher felony classification. Now, before I move on from the crime of theft, I just want to point out that here in Illinois, we do not use the term larceny. Larceny is a legal terminology that can be used like theft or in place of theft or used in conjunction with theft. But here in Illinois, we do not use the term larceny. We simply have charging for theft, deceptive practice, and then in some cases, disorderly conduct. And like theft, fraud is more legal terminology. There doesn't appear to be any specific charging for just fraud. Fraud is used in law enforcement reporting when property has been taken in the context of deception. So a person arrested by the police for fraud is likely to be charged with the crime of theft. Because remember, in the definition of theft here in Illinois, theft can be when a person takes control over property from another person by deception. So fraud here in Illinois is roped into and tied to the crime of theft. So now I have a piece of interesting information for you. Buddy Mom! Children are not a protected class when it comes to financial crimes. I find this really interesting because I have encountered many fortune tellers that refuse to read for children of a certain age because they are under the impression that there are legal or other liabilities associated for reading with children. However, especially here in Illinois, you are at far more risk reading for elderly people and the disabled. Here in Illinois, we have a very specific charge called financial exploitation of the elderly or disabled. A person commits this crime when they are in a position of trust or confidence with the elderly person or person with disability, and they knowingly, by deception or intimidation, obtain control over the property of an elderly person or a person with disability, or illegally uses the assets or resources of the elderly person or person with a disability. And specific to Illinois, an elderly person is described as a person of at least 60 years of age, which means that I am very nearly an elderly person. Love that for me. Disability in Illinois is defined as either physical, developmental, visual, hearing, or mental that substantially impairs basic living. So a person seeking restitution for financial exploitation in the case of a disability would have to articulate how their basic life functions are impaired by their disability to have this charging, unless of course they are of 60 years of age or older. Now, financial exploitation of the elderly and disabled starts at a class 4 felony level, which means at least 1 year in prison and up to 3 years. And this is a class 4 felony if the property was $300 or less. And like we saw with some of the other crimes that I listed, the classification rises with the amount of property taken. So it becomes a class 3 felony, which is 2 to 5 years of prison if the value of the property is more than $300 but less than $5,000, and becomes a Class 2 felony, which is 3 to 7 years in prison if the value of the property is $5,000 or more but less than $50,000. And then once we reach that $50,000 level, of course it goes higher up to a Class 1 felony. So were you surprised to learn that children are not a protected class when it comes to financial crimes? And if you are a fortune teller or are interested in fortune telling and have had those services performed, do you think that there should be age limits? Please let me know your thoughts in the comments down below. Now, in part 1 of Fortune Telling and the Law, I did spend a little bit of time explaining why there were prohibitions and regulations governing fortune telling in the United States. This was largely because fortune telling in older times was often used by con artists to defraud people out of their money. And unfortunately, the potential for people to be taken advantage of by unscrupulous fortune tellers, even in the modern age, is still very high. Not very long ago, in 2011, was the case of Patricia Johns of Lafayette, Indiana, which is surprising to me because that's very close to where I live in Illinois. Now, she persecuted many people, but I do have 2 specific stories to share with you. In one case, a widow was hoping to communicate with her recently deceased husband, and she went to Patricia Johns for her fortune-telling services to connect with her deceased husband. Johns then told this widow that evil spirits had contributed to the death of her husband, and then she told this widow that those spirits were now after her, and in order to protect herself and her family, the widow needed to purchase a crystal from Patricia Johns worth $40,000. With my understanding of the law, and my opinion is that this constitutes as a threat, because the widow was given a threat of harm, even though it wasn't Patricia Johns taking out a gun and holding a gun to the widow's head. She was using a threat of harm to coerce her into giving her that $40,000. Another client of Patricia Johns was desperate to save her failing marriage and paid Johns over $61,000 in multiple service. This woman was asked by Johns what her marriage was worth to her. And once again, with my experience with criminal law, my opinion is that this is a form of intimidation. She was intimidating this poor woman with the loss of her marriage and was able to extort money from her through that intimidation. So yes, once again, she wasn't threatening to break this woman's legs, but she was essentially saying that her marriage would end without her help. Now, these 2 particular clients were in very vulnerable states, but it is very easy for cunning con artists to take advantage of anyone from any walks of life. So I need to be very clear that it wasn't the fault of this poor widow and this woman struggling to save her marriage. While they were at slightly more risk because of their vulnerabilities, they were very emotional and they were very invested, I just want to make it clear they are at no way to blame. Anyone, no matter what their education status, no matter what their income level, no matter what their race, gender, religion, any of that, anyone can fall prey to a con artist. So really, we should put all of the responsibility on Patricia Johns. These people that she defrauded are true victims, and they are not in any way, shape, or form to blame. In 2015, Patricia Johns was fully charged and was convicted, but she was convicted of filing false tax returns. And actually, she received only 3 years on probation only. She never saw any jail time. I do believe that she had to pay fines, but she did not have to pay fines to any of the people that she defrauded. In fact, the widow and the grieving wife and the many other vulnerable people that Johns had defrauded through threats and intimidation they never had any of their cases brought to trial, and none of them received any kind of restitution, which I think is tragic and sad. I think the reason for this is that it has been my experience in criminal law that fraud, remember that is a part of theft, is very difficult to prove because the prosecutor has to specifically delineate how a person was intimidated and how they were threatened and how they were coerced into giving up their money. And unfortunately, it's a very easy defense to show that the money was turned over willingly. And that's the whole tricky part of that argument, because it was handed over, but it was done so from a very emotionally vulnerable state. And that vulnerable state can also be a heightened sense of happiness. Like if a con artist is validating you and inspiring you, that can also be a way to encourage and intimidate you to give them more and more money. So fraud is difficult to put before a jury of 12 people and get a successful criminal prosecution, which is probably why the state of Indiana went with just the tax evasion charges against Patricia Johns and decided not to pursue fraud charges against her. So while the charges of disorderly conduct, deceptive practice, and theft and financial exploitation of the elderly and disabled do exist, and I think do apply to fortune tellers, as we saw in the case of Patricia Johns, more than likely a fortune teller, if they are brought to trial, is going to be facing some kind of tax law, or as in the case of the part 1 fortune telling the law video, we saw some cases where fortune tellers were fighting smaller ordinances, which would have been no jail time served, but some fines and things like that. If you check the description box down below, you will find some links to some of the sources that I used for this video. But I have to tell you, the research that I did for fortune telling the law was so intensive that I actually surpassed YouTube's character limit on the description box. So what I did is I collected all of my resources and I put them in a blog article on my website, and I will have that link for you in those sources. So I have posted some of the most relevant pieces that I used in this video, like the Illinois compiled statutes link. But if this topic interests you, definitely checking out the full sources on my blog would be beneficial to you. Please stay tuned for part 3 of Fortune Telling in the Law, where I plan to discuss ethics and hopefully will give you some tricks to avoid unscrupulous fortune tellers like Patricia Johns. And until then, you might enjoy my video on questions you should never ask the fortune teller. And with that, my fair friends, have a magical day.